on that matter. And I apologise again for that.
I want to support the amendments in this group that probe how removing illegal material is understood and going to be used in terms of the bill. The noble Lord Moylan explained a lot of my concerns, as indeed did the noble Lord Colville via his avatar. And we have a range of very interesting contributions that we've heard so far that I think, you know, need to be taken very seriously by the government. And I put my name to a number of amendments. The identification of illegal material might well be clear and obvious in some cases, even many cases. It sounds so black and white, you know, don't publish illegal material. But particularly in defining communications, in defining communications of this nature, I think it can be highly complex. And it's so highly complex that it's traditionally reserved for law enforcement bodies and for the judicial system. We've already heard from the noble Lord Moylan that despite the fact that Home Secretaries, this House, regulations, all sorts of laws have indicated that, for example, non-crime hate incidents should not be pursued by the police, they continue to be pursued by the police as though they're criminal acts. So that's exactly the kind of issue we have. I noted earlier that the noble Lord Bethell made a passionate intervention about, of all things, Andrew Tate. And he talks about Andrew Tate's illegality in relation to this bill. So there's a number of things that prompted me to think. I mean, Andrew Tate is an influencer who I despise, and the kind of things that he says. But as far as I know it, the criminal allegations he faces are not yet resolved, so he has to be seen as innocent until proven guilty. And most of what people say, you know, he has online that's egregious might well be bad taste. I would say usually is misogynist, but it's not against the law. And I just was wondering, I mean, if we get to a situation where that's described as illegality, that's the kind of thing that I worry about, because removing so-called illegal content for the purpose of complying with this regulatory system does cover that kind as we've heard from other noble lords, will mean those kind of dilemmas or the kind of things that are faced. Yeah.
Noble Baroness, in talking about that individual's own investigations reminded me of one of the classes of content where you do have clarity, and that's contempt of court. And that's actually a very frequent request, and you know it's illegal in that case because a judge writes to the company and says, you must not allow this to be said because it's in contempt of court. But that really is the exception. In most other cases, someone is saying, I think it's illegal, except when it's a live proceedings. And in those cases, it's absolutely clear because the judge has told you.
Removing, I mean, that was very helpful. And what I'm concerned about is that removing so-called illegal content for the purpose of complying with the regulatory system covers not only that which reaches conviction in a criminal court, but could be anything that a platform determines could be illegal, and therefore is actually undermining our own legal system. That is partly my point. And that does mark a significant departure from the rule of law, as I've said, and it seems to be that the state is asking or mandating private companies to make determinations about what constitutes illegality. The obligations for platforms to determine what constitutes illegality could obviously become a real problem, particularly in relation to limitations on free expression. As we've already heard, offences from the Public Order Act of 1986 criminalises, for example, those who stir up hatred, and through the use of words, behaviour or written material. Now, this is contentious offline in the law. When I say contentious, it's a matter of difficulty that requires the full rigour of the criminal justice system, understanding the whole history of established case law. And that's all necessary to make a conviction under that particular law of the offences of this nature. Now we appear to be saying that without any of that, social media companies should make the decision. And I think that that is a nerve-wracking situation to be in, because we've already heard about this slippery phrase, reasonable grounds to infer. Reasonable grounds to infer, I mean, if that was the basis on which you were sent to prison for an act, you know, they didn't have to prove that you were guilty, but they had reasonable grounds to infer that you might be without any evidence, I would be worried. But reasonable grounds to infer that the content could be illegal is the basis on which we're asking for these decisions to be made. And that's significantly below the ordinary burden of proof required to determine that an illegal act has been committed. And under this definition, I do fear that platforms will be forced to over-remove and censor what ultimately will be entirely lawful speech. I do want to ask the Minister to consider what competency social media companies have to determine what is lawful. And we've heard some of the dilemmas from somebody who was in that position, let alone the international complications, as was indicated. But, I mean, I just see all of these big tech companies and social media. I mean, are they going to have to employ lots of ex-policemen, you know, criminal lawyers? I mean, how is it going to work? It seems to me to be a real lack of qualifications in that sphere. And that's not a criticism of them, because they've decided that they work in big tech, not in criminal law. But we're asking them to pursue this. So that's something of concern. I also wanted to just make reference to the controversies, I think anyway, around the government's amendments 136 and 136A and 136B as to indicate the difficulties. This is the government saying that, that illegal activities such as assisting unlawful immigration or illegal entry in similar offences or on human trafficking. And I was just a little unsure as to how this would operate, because it will be the case that there is certain entrance to the UK that is illegal. But I suddenly have this envisage a situation where a perfectly legitimate political debate about, for example, the small boats controversy would be taken down, and that people who are actually advocating a position against the government's new illegal migration bill could be accused of supporting illegality. I mean, what is it exactly that is going to be made illegal in those amendments in relation to the online safety bill? I did think that, right, so that's on that bit. I did think that the Noble Baroness, Lady Buscombe, by the way, made a fascinating speech about a really interesting group of amendments. I think it's something to do with the way that these amendments are grouped, that I feel like this is a completely different debate. So I won't go into any details at all. But I would state now that anonymous trolling or Twitter storms or spreading false information, all of which are incredibly unpleasant, and I'm often the recipient of it, so I know once a week at least. You know, you'll have a Twitter storm, everything about it, and you feel so frustrated that people are just telling lies, and, you know, your reputation being sullied. However, I do not think that should be the basis on which they are censored, I'm afraid, and I definitely will be arguing against removing anonymity clauses. But that will be in another group. But I just want to say it's a real problem. I don't think the solution is contained within those amendments.
My Lords, I just want to rise and say a few remarks.